Good morning and welcome to the ABA's webinar on COVID-19 and child welfare cases. I'm going to start by introducing the ABA President, Judy Perry-Martinez, who will give some introductory remarks.
Well, good morning, everyone, and thank you for joining us for this ABA Rapid Response webinar on COVID-19 and child welfare cases. To provide resources to our section members, the greater ABA, and the general public, the ABA section on civil rights and social justice has developed a multi-part webinar series exploring how the COVID-19 pandemic is affecting so many critical legal fields. And today's webinar is being hosted jointly between the section on civil rights and social justice, the ABA Center on Children and the Law, and the ABA Commission on Youth at Risk. I want to begin by expressing my appreciation for all of you professionals who have joined here today who come from the child welfare field, attorneys and caseworkers, peer advocates, social workers, judges, court improvement program staff, agency directors, CASA volunteers, kin advocates and caregivers, resource and foster families, and many others who are working each and every day at everything they do to support children and families with compassion and care during this pandemic and its challenging times. Today's webinar is designed to help attorneys and judges and others apply the Children's Bureau's recent guidance and case-by-case decision-making to address legal issues around family time and access to services in the case plan, remote court hearings, reasonable efforts and termination of parental rights timelines, family reunification, and other important aspects of child welfare cases affected by the pandemic across the country. We're also extremely grateful to our wonderful participants in today's calls and the work they are doing in communities across the country to serve children and families' needs, and the work they are doing nationally to help us navigate the many challenges that this pandemic has presented for child welfare cases. We are so glad that you could join us today for a discussion of this important topic that the ABA is bringing to you. And with that, I'll turn it over to our moderator and to our panelists. Thank you so very much, panelists, for bringing your expertise to everyone today. Our moderator is Prudence B. Lacard, the director of the American Bar Association Center for Children in the Law. Thank you, Prudence.
Terrific. Thank you, Judy. And I'll begin by echoing your thanks to all of the terrific panelists and also all of the child welfare professionals who are joining us from across the country today and who are facing incredible challenges in their work on a day-to-day basis right now. I am honored to host today's session. I wanted to begin by giving just a quick overview of what the structure of the webinar will be. The focus of the webinar is on highlighting the Children's Bureau's recent federal guidance to child welfare leaders across the country on how to handle emerging challenges for the legal field in child welfare cases that are both pending and forthcoming. During the webinar, we'll hear directly from the authors of that guidance, Dr. Jerry Milner, the Associate Commissioner in the Children's Bureau, and David Kelly, a special advisor at the Children's Bureau at the U.S. Department of Health and Human Services. We'll also hear directly from Judge Ernestine Gray from Orleans Parish, and who's the current chair of the ABA Commission on Youth at Risk. And she'll give us her perspective on how that guidance can be implemented from the bench. And then we'll also hear from Kathleen Creamer from Community Legal Services in Philadelphia about the attorney's role in implementing that guidance and what she's seeing on the ground in her advocacy. Kathleen is also a member of our ABA Family Justice Initiative and the National Alliance of Parent Representation. Thank you so much for all of you joining us today. One other structural caveat that I will share is that we received many, many questions in advance of the webinar, and we have collected those and shared them with each of the speakers. Many of the remarks shared today will incorporate those questions into the remarks, but we won't have time for any live Q&A given the magnitude of registrants and the short timeline that we have on today's webinar. So thank you so much for the questions that came in. If you have additional questions, please feel free to continue sending those in the links that have been provided. And with that, I will say we are ready to begin. I will start with Dr. Milner, a question for you. In March, the Children's Bureau issued a letter, Dr. Milner, to judicial and legal leaders across the country, providing guidance to address ongoing responsibilities in child welfare cases, and a letter that really urged courts to continue judicial oversight during this pandemic. Can you explain a little bit, Dr. Milner, why the Children's Bureau felt the need to issue this guidance and what the Children's Bureau is hoping to see as a result of the letter that came out?
Yeah, thanks. Thanks so much, Prudence. Happy to talk about the motivation for the letter. I do want to start out. I'd be remiss if I didn't recognize the incredible heroic efforts of our child welfare workforce out there through this very, very difficult time. The social workers who are out there still trying to see children and investigate reports and carry on. The attorneys who are representing our parents, children, the agencies, the service providers, the judges. It is a time when people are stepping up, and we are quite cognizant of that. I also want to thank you for hosting this webinar and putting us in front of so many people here. Just to be really clear, you know, we have always been of the firm belief that the legal and judicial community plays an incredibly vital role in our child welfare system. And your roles right now, frankly, are even more important, I think, during this time of crisis when we face such a challenge. We wrote the letter primarily in response to a number of concerns that we were hearing in the field about dependency courts closing in some situations indefinitely, that a lot of the hearings that offer protection to children, reviews, were being postponed, and that in some situations blanket orders were being issued that would suspend parent-child visitation. We understand very clearly that we have to take appropriate safety provisions, but at the same time, we are also very concerned about the safety, the healthy development for very young children, and concerned about progress toward reunification. We felt an urgent need to get a message to the field that even with the crisis going on, and as difficult as it is, we have responsibilities that we still all collectively must strive to meet. We are looking at all of the requirements that are out there. And this is an ongoing process for us. Some things we have the ability to waive administratively. Some things would require a legislative fix, even though we may not have the ability to totally waive certain required hearings. We are looking at time frames for making some determinations. I want to take this chance to say that we remain absolutely committed to the concept of reasonable efforts and reasonable effort determinations. It's something that we have spoken very, very frankly about, and believe that we continue, maybe even more so now, must continue to make those reasonable efforts to keep families safely together when that's possible, and to achieve reunification or other goals of permanency when it's not possible. I think this time is testing our creativity and our ability to be innovative and in good ways for the most part. In other situations, it's quite a challenge out there. We recognize that hearings, reviews, determinations may not be able to occur in a physical courtroom, but it is that commitment to the process behind that we think must continue, however we're able to move beyond that. I'd actually like to spend just a few minutes, if that's okay, going through the main provisions of the letter, because I think it's important to be clear about what the letter says and what it does not say. We are aware, as with any kind of communication like this, that there will be different understandings of what we're trying to communicate, and that this is no exception. I want to be real clear that we've never suggested or said that during this time of crisis, when there are public health safety precautions in place out there, we've never said that the courtrooms need to remain physically open and that all hearings must be done in person. In fact, we've gone to great lengths to say that we need to look for alternate ways to continue those processes. We've also never said that all parent-child visits have to be in person. Some, we believe, can be in person, but in other situations, it may be the most appropriate thing to find other ways for parents and children to communicate and to continue that relationship. We are firmly committed to the principles that have always been in place around child welfare and the judicial determinations, that those decisions and determinations should be made on individual child and family needs and their circumstances. And be quite frank, blanket court orders tend to run counter to that. In the letter itself, I hope most people have had a chance to read it. We have pointed out the hearings and the determinations that must be made, the contrary to the welfare determinations, reasonable efforts to prevent removal, to finalize permanency plans, 6 months reviews, and 12-month permanency hearings. We are, again, to repeat myself, still exploring some of our flexibilities there. We may have some flexibility on time frames, although, as I've mentioned, we are totally committed to the determinations around making reasonable efforts. Hopefully, we'll be able to supplement whatever guidance we've already put out there as we're able to get things cleared and as much flexibility as we can while still protecting the health, the safety, the well-being, and the integrity of our families and parent-child relationships. As part of our letter, we have underscored the fact that we think it is critically important that parents and children continue to be able to meet with, speak with, stay in frequent communication with their attorneys. We have urged the courts, the attorneys, the court improvement programs, and administrative offices of courts to work together to ensure that parents, children, and youth are well represented and able to participate in proceedings, whether those are virtual proceedings or in some other venue. We've encouraged the attorneys to stay in close contact with their families and their children any way that they're able to do that, and to bring urgent issues to the attention of the courts and to all parties. Our letter was a call to refrain from making sweeping blanket orders that postpone hearings or postpone visiting between children and parents. Again, not to be overly repetitive, but the criticality of those activities, I think, is underscored in the situation that we're in. We're encouraging the courts to make case-by-case decisions in accordance with the facts on each individual matter. We've encouraged all parties out there to make maximum use of technology so that we can ensure due process where in-person hearings are simply not possible or appropriate to continue. We've asked that agencies out there ensure that parents, that young people have access to technology such as cell phones, tablets, computers with internet access. We will be forthcoming with some additional guidance in this area around how we at the federal level may be able to support that technology financially, because we know that a lot of parents and young people simply do not, we take it for granted that everybody has got that technology available to them. And in fact, we know that that's not always the case there. We are encouraging the courts to work closely with the court improvement program folks in their states, and to look into utilizing CIP funds to support, to enhance virtual participation for parents, children, youth in hearings and reviews. The letter also gets into some detail around making decisions where possible. If all parties can agree, we've encouraged making agreed upon decisions through stipulated orders as opposed to necessarily having to wait for an in-person hearing. So those processes, those legal judicial processes that we feel so strongly about are addressed, I think, in a fairly straightforward way in the letter, and while giving and encouraging as much flexibility and creativity as possible. The letter also, as I mentioned earlier, did address the whole area of blanket orders, suspending or drastically reducing family time. You know, we understand the rationale behind that. There are public health situations, considerations to be made there. We don't encourage folks to violate public health directives that are in place in their jurisdiction, but we also understand that family time is especially important during a time of crisis, when children may not understand what's happening or when they're going to be able to see their parents again, or even if they're going to be able to see their parents again. We are encouraging orders again to be specific to each child and family, being mindful that there may be other ways of keeping that contact going if we're able to be innovative, but also asking parents, you know, what their preferences are. I think that there'd be a lot of parents out there that would say the risk is too great, and we would prefer to have a virtual contact there. But doing that on a case-by-case basis, we think it gives us the best opportunity to reduce the likelihood of further trauma that has already been in place with our children and families through absolute just removal from each other and the circumstances that may have led to the removal. The letter also addresses a critical need to continue to see that parents and kids receive services and treatment. One of the very difficult barriers that has emerged through this crisis is the inability of some of our community-based service providers to continue working with children and families. To that extent, getting the services out there may be out of our control, but we have issued a strong encouragement to do everything that we can do that is within our power to see that families, parents, kids, our young people out there continue to have access if we're able to do that and get the services. This is reasonable efforts that constitutes our efforts to achieve reunification and help families avoid getting into very difficult situations around timelines for reunification or threats of termination of parental rights. Finally, our letter recognize that there are costs associated sometimes or fees for litigants in order to participate virtually in hearings out there. To the extent that we have control over that, we have certainly urged a waiving of those charges or to suspend charges in light of the present circumstances. Along with our letter, we sent out a fairly comprehensive list of low or no cost communication platforms, applications that would permit families to participate. And we're continuing to do research on what kinds of resources there may be available for families and young people to consider there. I'll just sum it up here by saying, again, we're working very hard here to make sure that child welfare agencies, the courts, all players out there have the tools, the resources, the flexibilities that they need to continue their work safely. Some of the alternatives are not optimal. We know that, but we're not also in an optimal time in our lives right now, and a lot of our work out of necessity will have to be performed remotely or virtually through teleconferencing, phone applications, other technology that's out there. We're just strongly encouraging to the courts and the agencies to help parents, help families, help kids have the tools that they also need during this critical time to be very concerned about their overall well-being, in addition to obviously their immediate health and physical safety. So thanks.
Thank you, Dr. Milner. That was a very helpful overview of the guidance that the federal government has provided, and we're incredibly appreciative of the federal government tackling these issues right now. In answer to some of the inquiries that have come in, there is a link available to the letter on the HHS Children's Bureau website. We also have a link to the letter on the ABA Center on Children and the Law website homepage. And we can send that out to those of you who haven't had an opportunity to review the letter. We will send out a follow-up link after this program as well. So thank you for that inquiry. I'm going to turn it now to David Kelly. David, you're an attorney who has experience having represented children and parents in child welfare proceedings, and having spent the past 10 years working within the Children's Bureau in partnership with the court improvement programs across the country. I'm curious to hear from your perspective, based on those combined experiences, what's your hope about what you would like to see the child welfare field do with implementation of the guidance that the Children's Bureau has been sharing?
Sure. Thank you, Prudence. And again, thanks to the ABA for holding this forum. It's really wonderful to share this hour with so many good friends and colleagues, and you're all deeply appreciated. If there's one simple takeaway from the guidance, it's that the work must continue. This is not a time for impoverished thinking, knee-jerk reactions. It's a time to be thoughtful and creative and act with true intention. And this need applies equally to judges, attorneys, and child welfare agencies alike. We simply just can't deny justice and support to poor families when they need us most. We fully appreciate that people are scared and uncertain how best to proceed, but we can't give up. We want to be really clear that we're grateful for the social workers, as Jerry mentioned, and other agency staff that are facing, frankly, unprecedented risks and challenges right now. And we're equally as grateful for the attorneys and judges that are demonstrating leadership and taking initiative. I'm hearing directly from attorneys and judges out there around the country every day about what they're doing, and it's remarkable. But we really cannot emphasize the gravity of the need for continued judicial oversight enough. And we can't emphasize the gravity of the need for continued justice, access to justice, and zealous legal advocacy enough in this moment. We're aware that, as Jerry said, some courts have issued blanket orders suspending all civil proceedings. But I would ask that we reflect a moment on on what's at stake here. You know, these are not, dependency proceedings are not typical civil proceedings. We're dealing with fundamental liberty interests here of parents, and we're dealing with the health and safety of children and young people. These are issues that require incredible attention and care always, and especially now. You know, we're not talking about slip and fall cases here. We're talking about children's lives and family integrity. And we really believe this is the time for more judicial oversight and accountability, not less. And that we need robust out-of-court advocacy by attorneys more than ever. It's a time for more communication between attorneys and parents, and attorneys and children that they represent, not less. It's time for attorneys and judges to be creative and look for new ways to do the work. We need vigorous motion practice, written certainly, and perhaps even oral over the phone. We need creative legal arguments and creative solutions. And attorneys can demonstrate right now that they are proactive problem solvers. On the court side, juvenile courts need to lead by finding ways to remain operational, even if the physical court building is closed. Courts need to be transparent in how issues will be resolved and establish guidelines. Judges can send really powerful messages that advocacy is welcome and needed at this time. And there are easily just 3 or 4 very, very basic things that any court could start doing now that we believe would help stem the tide of the crisis. And that would include writing court protocols and expectations of how court will continue to operate, holding virtual hearings and reviews and case conferences, pushing attorneys to try to resolve issues through stipulated orders, and making prompt decisions after motions and virtual hearings. You know, we really think we can use this moment to move away from what are all too often pro forma hearings and reviews and hold meaningful conversations about how families and children are doing, what they need, what kinship providers are doing and what they need, what resource families are doing and what they need, and what we can do to help. We can move away from mechanically checking boxes on court orders and focus on what children and families need and how we can provide it. And one of those things that we know is needed now more than ever are relationships and supports. They're critically important during this crisis and with the social isolation. And we can all focus on doing what we can to nurture them, no matter what our role is. We got to be creative. If services can't be provided, we have to be mindful of how their absence will affect progress. We should not enforce timelines in a way that penalizes parents for these absences and shortcomings. And attorneys and judges really need to be prepared for the aftermath of this public health crisis and factor service and delivery interruption and limitations on family time into their arguments and into their decisions relating to reasonable efforts and compelling reasons not to file terminations of parental rights. As Jerry mentioned, we believe that court improvement programs are a tremendous resource for judges and attorneys right now. We expect, as always, CIPs to work closely with chief justices and AOCs in every state and territory to help meet this challenge. And right now, CIPs across the country are providing critical support to ensure safety and well-being and to protect important constitutional rights during this pandemic. And just a few that I've been made aware of in terms of CIP examples include purchasing technology to allow hearings to continue remotely, working to develop protocols for remote hearings, providing remote training to judges, court administrators, clerks on how best to use those technology platforms. CIPs are working very closely coordinating pandemic responses with child welfare agencies. They're providing remote training to attorneys for children and parents in the Child Welfare Agency on how to use these technology platforms and assisting with setting up ways for attorneys to communicate with their clients, and supporting virtual hearings and reviews. Again, the takeaway here is that work can and must continue. The stakes are simply too high for it not to. It will need to look different and require creativity, but stopping is not an option. With that, I'll turn it back to you, Prudence.
Thank you, David. Thank you for all of the remarks, but especially reinforcing that this is not the time to be pushing pause on any cases that involve the fundamental rights at stake in child welfare cases. I think that's a terrific segue, building on your comment that this is a time when judicial oversight of child welfare cases is needed now more than ever. I think is a very good segue for us to turn to Judge Gray to share with us what she's seeing on the ground as an active judge in Louisiana, and also her perspective about how having federal guidance on these issues can be effective in her role in judicial decision making. Thank you, Judge Gray. Judge Gray, you're still on. You're on mute on your. You're still on. There we go. Perfect. Thank you.
Am I still muted? Okay. Thank you, David and Jerry, for your comments. I want to start by recognizing the incredible efforts of the stakeholders in this work, in particular, the agency and their staff. I was on the phone a few days ago with staff from the Department of Children and Family Services in Louisiana, and they too are dealing with death of staff members, loss of family members, and they're dealing with, the foster parents, resource parents who are a parent who's ill, one parent ill, and the other parent is at home with children. So they are under some incredible situations in trying to do the work. Having said that, however, I also want to pick up on what David said about the absolute necessity for going forward and having these hearings. If you recall, the United States Supreme Court, as I interpret what they said, was termination of parental rights is tantamount, similar to putting someone to death. That's really serious. And so that's the kind of approach we need to have when we're dealing with these cases. It is not to be taken lightly. These are serious cases that we're dealing with every day. I think what we have to remember is that one of the reasons I think the blanket orders are problematic is, again, touching on something that was said already, is that we're supposed to decide cases on an individual basis, case by case. And so what might be appropriate in one case, that we have no hearings, we have no reviews, we have no parent contact or child contact, is not necessarily appropriate in 5 other cases. And so what I would encourage and say, that we have to remember that each case is a different case. And then the other thing is that, as we are working to try to make sure we provide services, I was also provided with information that some of the services that are available in New Orleans, they are providing remotely and virtually, which is really heartwarming. And I think we need to figure out how to make that happen in more cases. Obviously, it's harder depending on what service we're talking about. So it might be harder to get substance abuse treatment virtually. But I'm not sure that we should just automatically say we can't do that either. We need to look at whether or not we can. I think that the letter for me that was written by the department, as a judge who's always maybe known for pushing the envelope a little bit. So it provided a basis for the judge who receives from their Supreme Court or their administrative court an order that says no hearings. It provides the basis for that judge being very proactive and going back and saying, yes, I understand that, but look at what it says we need to do in these particular cases. This is why we need to move forward. And whether or not people will adhere to or believe, one of the strong points of the letter is that if we fail to make certain decisions, then the state loses forever its ability to draw down federal funds. From what I know of most of the states that I have friends in and deal with colleagues around the nation on, the states really need to be able to draw down federal funds. And so it shouldn't be taken lightly that we can just not have these hearings and everything is going to be okay. And I think that that is one of the crucial things that we need to stress with our colleagues, that we have to make these hearings in order to be able to draw down the federal funds. I think what I've seen from colleagues around the country and what I have learned from watching many webinars is that courts who were already more technologically advanced are having a little bit of more ease in getting up to speed. So if courts were already, and there are some who were already doing electronic filings, they were already conducting some remote hearings already on some issues, maybe not necessarily in child and needed care cases, but they had the technology and the ability to do that. It's easy to convert to doing sync cases that way. If a court had not done it at all, judges are really scrambling with trying to decide which platform, and there are many, as Jerry mentioned, there are many platforms, so judges are trying to decide which platform. People are concerned about confidentiality on one platform or another. Those are issues that we're grappling with as we try to figure out which platform to use. And I think we have to give the ability to work through those with the lawyers and the parents and the children around those concerns. And so the issue of confidentiality has come up, but it's not a reason to not move forward with these virtual hearings. And so there are ways to deal with that. And I would encourage people to figure out how to do that. I think that it's correct that many of the parents won't have the technology to necessarily participate in the virtual hearings, but I'm sort of hesitant on that because many of them you can do contact with a cell phone, and most people have a cell phone. Now they may have limited minutes, they may not be able to do certain functions on their cell phone, but they at least have a cell phone. And then our challenge is to be able to try to help them get more minutes, help them get updated technology so that they can participate in these hearings. But I think the challenge is, and what is important to stress is that we've all have to be open to doing things differently. I don't think that when this pandemic is over, we'll ever go back to business, quote, as usual. That is not going to be the way we live and work in this country, in this sphere, I don't think. And so figuring out how to move forward, maximizing the technology that is available, making sure we're bringing everybody along, parents, children, foster parents, resource parents, the workers and the lawyers, everybody along till we get to the same page, and then be able to have hearings when we need to. There are some courts who are doing limited hearings in court where they are only having 2 people in the courtroom. And it's different because some hearings in some states are open and others are not. If the hearing is open and not closed, then the judges are having people come to court or making it available for people to come to court. I was on the phone with someone a couple of days ago who said, I'm not in the courtroom, but I have said, because my proceedings are open, I've said that if people want to come in the courtroom, we will enforce the social distancing. We won't have a courtroom full of people, but some people can come in. We are broadcasting our hearings so that they can see them. And so I think that we've got to figure out how to do all of that so that we maximize people's ability to participate.
Terrific. Thank you, Judge Gray, for all of your guidance and concrete ideas, as well as for everything that you're doing day to day to continue to provide access to justice for families who come before you in your own jurisdiction. Kathleen, I think that's a fantastic point to build on. One of the comments that Judge Gray just made was this willingness to be open to doing things differently, and to tie that with some of David's guidance as well. I thought it'd be great to hear from you as an attorney who's on the ground doing some of those creative lawyering, making sure that you have very active communication with clients. And I know filing a lot of motions and figuring out how to help make sure that we are all being open to doing things differently. Can you give us some updates about what you're experiencing as an attorney and guidance on how to be as Ellis advocate right now for families and children in your jurisdiction?
Sure. And I first want to say what an honor it is to be part of this panel, and also to be in the virtual room with so many of you folks who are doing this really important work. I know I feel personally that my team is doing some of the best and most important work of their lives. And I imagine that so many of you are also doing that right now. And I just want to thank you for that. For those of you who don't know me, I know I have a lot of friends on the call, but for those of you who don't know me, I manage a small family defense practice. We have 7 lawyers, 3 social workers, 2 paralegals, and with a grant from our city, we recently brought on a peer parent advocate who has lived experience herself. And I can tell you for sure that this has been a time where I've seen an all hands on deck approach with my staff very much. We are always driven by the understanding that we all share right now of the trauma of family separation and the grief and loss that all of our parents and children who are separated from each other are experiencing in the child welfare system, and then a really profound understanding that what people who are in grief and loss and trauma need more than anything is connection. And unfortunately, that is what we are all challenged with, giving and receiving in these very difficult times. So much of our advocacy right now is driven by what we know about the needs our families, our parents, and children have to connect to one another. We always believe in our practice that the most important work that we do, the most important advocacy that we do as a holistic practice is the work that we do in between court hearings, but we are taking maximal advantage of the access that we are able to get to the courts. So just to give you an example, we did have one of our fabulous attorney interdisciplinary teams win a shelter care proceeding. We had a mother who was in a mother-baby program who was separated from her infant. We did prevail at that proceeding. And what that means is that for these next few weeks, as we go through this period of prolonged separation, that baby's in her mom's arms for those weeks. And what it means for our client is that baby is in her arms for those weeks. And an added bonus for this particular client is she wasn't made homeless because she got to stay in her mother-baby facility. So those wins are so precious for us. I want to also talk a little bit about some of the outside of court work that we're doing because it's just as important. One thing that we're thinking about very much is how fragile our families already are and how that fragility is really magnified in this situation, and paying very close attention to our clients' collateral needs for civil legal aid, for food security, for housing security. Those are high priorities for us right now. We're doing a lot of advocacy around visitation, around making sure that our parents are able to have, first and foremost, the technology that they need to participate if they're getting virtual visits. One of my social workers yesterday just signed a bunch of our clients up for free Comcast. Ironically, the best way to sign up for free Comcast is to go on the internet. And so there's a little chicken and egg problem there, but we're resolving that for our clients on a case-by-case basis, trying to advocate to make sure our clients have the equipment they need, the supports that they need. And then a lot of our advocates recently participated in another webinar about how to make virtual visits meaningful, especially when you have those young children under 5 who struggle with that, how to make those meaningful. And we're all kind of excited to be armed with tips to support our clients as they do these visits. We are trying to work on agreements outside of court to reunify families when we can, and working on reaching out to opposing counsel, reaching out to the Child Welfare Agency to try to get stipulations and agreements. And then one thing that we're really focusing on right now is the trauma that our clients are experiencing. This is a time, again, when a lot of us are in crisis. I know half of us on this call are probably running homeschools and caring for sick relatives on top of our full-time day jobs. But again, I really believe that this time is the opportunity for all of us to do the best and most important work of our life. And some of that for our clients and our families means that we're honoring who they are in their full humanity and reaching out to them right now and understanding that, even though we ourselves are in crisis, our clients are in a very special, unique kind of crisis that has been significantly exacerbated by this situation. But we've always believed that every family separation is a crisis and it requires an all hands on deck approach. So our social workers, our peer advocate, our paralegals, and our attorneys are all reaching out to our clients on a regular basis and asking how they are and checking in with them. My social worker was just telling me yesterday, she's reaching out to clients and saying, how are you coping and what's your plan to get through today? Because coping strategies are really important for all of us right now and have never been more important for our families who are really struggling with the pain of being separated at this time. I also have been really inspired by our attention to all of our clients' needs at this time. Our peer parent advocate has actually been cooking for some of our clients. We have a client right now who is in deep trauma. She's been separated from her infant and she's married to a healthcare professional, and she's immunodeficient and so has to be separated from her husband at this time. So she's missing both her husband and her child, and she's not eating. And my peer parent advocate's very worried about her and said, could we get you to drink a smoothie? If I dropped off a blender at your house, could you drink a smoothie? And she did. She dropped off a blender outside of our client's house using social distancing. So I want to emphasize, this is the time to be all hands on deck. Our families are in crisis right now. We're using every legal strategy that we have, but we're also using all the other strategies we have to recognize the full humanity of our clients and the crisis that they're in right now.
Kathleen, thank you so much. I want to make sure that we have one more opportunity for all of the fantastic panelists to give some additional thoughts. And I think that your comments about just recognizing the importance of bringing humanity and compassion to this period of time, both in the lawyering role, but also in all of the ways that human contact, even during physical and social distancing, is critical to support one another. And so I want to actually turn to this question and open it up to each panelist to give us their thoughts on, which is, when we have a chance to emerge from this crisis and to take a step back and look at how our field handled it, what are the successes that we want to be able to look back on? What are the ways that we want to be able to feel like we did get some of this right, even though it is such a complicated period of time and there are new challenges in every individual circumstance. And so I'm happy to go through maybe sequentially the same way that we did the panel, but I'd love to hear each of your thoughts about sort of how you would define a positive thing to look back on for our field when we revisit this time period in the future. David and Jerry, maybe one of you can start, and then we'll shift it to Judge Gray and Kathleen as well.
David, go ahead. I guess.
Go ahead, Jerry. You're
okay. You know, as we go forward here, Prudence, I think there are two things that I want to make about how we will know if we've been successful here and moving forward. And I think in the first is the knowledge, the confidence that we've done all we could to mitigate the trauma for children, for their parents, for their families. We may not be able to avoid all of the trauma, but everything within our power that we've done to protect not just their physical health and safety, but their well-being and the integrity of those relationships will make me feel like we have had some measure of success. The second area, I think, is that Judge Gray has already said, we're not going to go back to the normal that we've already experienced. I think that's a good thing, because I think that our normal before this crisis was not working as well as it could or should for parents, for children, for young people. So my hope and a measure of success for me is that we emerge from this with a much greater awareness of and a commitment to resolving the weaknesses in our child welfare system that are absolutely laid bare by this crisis. As an example, we have always known that our social workers, our attorneys were overworked, had too high caseloads, overstressed, and now that burden is more apparent than ever. We've always known that community-based service providers are essential to meeting the needs of children and families. And now seeing the struggles and the fragility of those agencies just to stay afloat make that even more abundantly clear to us. We've always known, quite honestly, that our court system was not nimble, agile enough to keep up with the demands. And now the struggles with electronic capacity, adaptation to the situation we have only underscores that lack of agility. We've always known that parents and children need greater family time together when they're separated through foster care. And now the threat to that time together should raise our awareness of the critical importance of family time more than ever. And finally, I'll just say, we have always known that as a child welfare system, we let our young people age out with a lack of permanency, a lack of connections in their lives when they're as young as 18 or maybe 21 years old. And right now, as we see dormitories at colleges and universities closing, and those young people being at incredible risk of homelessness, lack of support, lack of connection, that weakness in our system has never been more apparent. So a measure of success for me would be to learn from this, to commit ourselves to dealing with those weaknesses on behalf of our children and families.
Thanks. Prudence, I would add that this crisis is an opportunity really to awaken collective compassion and for us to begin being better able to see ourselves in the families and young people that we work with, because I have seen very little evidence that that's done routinely. And the trauma of experiencing our system is real. And we need to be very, very mindful of that. I think the measures of success I hope to see the most are signs that we're realizing where we fall short. We're seeing opportunities to do better, and that we can become a more humane and more just system as a result of what we're all experiencing in our personal lives and professionally. It's a defining moment, and we can seize it.
Kathleen and Judge Gray, we'd love your thoughts as well.
I don't know that I have much to add to what David and Jerry said, but I would, so one of my big issues has been overrepresentation of minorities in the child welfare system. And I think, unfortunately, this, as it plays out, may further cause it to be, there to be more overrepresentation. We know that, for example, in Louisiana, 70% of the people who've died from the virus have been African Americans. And so the disease is obviously impacting poor and minority communities. And I worry about whether or not that will mean that more of those children will come into the system. I hope not. I think we have to pay attention to that. This is a system that really, the people who come through the system are people who are poor, who are minority, and we need to figure out how to change that dynamic. I would hope that what we learn, for example, as courts, using technology, that we will incorporate it for forever, not for this time of this crisis. And so that we will continue as courts to keep up with advances in technology, that we will push for courts being as technological as possible, that we will push for the ability of young people and parents to be able to, even in times of non-crisis, if their schedule does not allow for them to come to court, that we still encourage the use of those virtual means for having hearings. We know that even as we have been going forward, requiring parents to be in court is sometimes quite a burden. There are transportation issues, there are childcare issues. And if we can, as we talk about being humane, understand that people that we have their cases in court, just like we can't be in 5 places at one time, they can't either. And so that we really be careful about how we are using this technology to move the cases forward. I would hope that, we now know that while the state agency may say that a 1 visit per month in person for a worker is what is required, that is not the only visitation that occur. We know that now we can have visits virtually. And so I hope that we will encourage the workers to have that 1 in-person visit, if that's all they can have. Quite honestly, in my cases, I require more than that. But if they can only have 1 in person, that they will use technology to enhance their contact with their parents and their children. Those are the kinds of things that I hope we will learn and keep ever present in the work that we're doing. I agree with Jerry. We've said that the system isn't a good system the way it was. And this perhaps is the opportunity where we can get the system that we believe would be best for everybody.
And I would just love to add to that. I think I'll say in my own state and in my own city, over the last decade to 2 decades, we've learned so much. And a lot of my measure of success when we come out on the other end of this is whether or not we've continued to honor what we know. We know that the voices of parents and children affected in our system must be centered and elevated at all times. We know that family engagement is one of the best ways that we have to keep kids safe and stable. And we know that separation of families causes extraordinary trauma, and that one of the best ways to heal trauma is to ensure that every family receives connection. So I hope that through this whole time, we're holding ourselves to what we know. We're measuring our actions now according to what we know, and we'll come out of this on the other end knowing that we behaved with integrity for our children and our families.
Thank you all tremendously. I think a nice way to close that question out is actually to share a story that I just heard. There's a historian named Nancy Bristow who wrote a book about the 1918 pandemic, and as part of her research for that book, she interviewed individuals who survived that pandemic. And one of the people who she interviewed was a woman named Lillian, who was 85 when she interviewed her. And Lillian was 3 months old when the pandemic in 1918 took her mom's life. Lillian doesn't remember anything about the pandemic, but she knows that she lost her mom, and she also lost the rest of her family because the community decided that it wasn't appropriate for her father, who was healthy and stable, to take care of her and her sister. And so they removed her from his care as a single father and moved both her and her sister to different relatives. And when she talked with Professor Bristow about what happened during that pandemic, she was very clear. And she said 85 years later that although she doesn't remember the pandemic itself, she has always thought of it as something that stole from her, something that cost her something, because she was not able to live with her sister or her father as a result of decisions that were made about her family. And I wanted to share that story as we cap off the webinar because I think that it's such a compelling counterweight to everything that we've heard from the speakers today. And even a contrast, Kathleen, to your example of the case where you were able to achieve reunification between an infant and a mother recently. And so I do hope that we sort of think of that voice, that when we look back on this period of time, that hopefully, Jerry, to your point, we have minimized the number of circumstances where someone 85 years from now will say that pandemic cost me something because of decisions that were made about my family that were related to other people's values or other people's opinions. And I just want to sort of finish by saying an enormous thank you to everyone on this panel, but also to all of the participants. This was an extraordinary number of registrants. And so thank you for all of your commitment. We will send follow-up materials as has been requested in the chat. And thank you to everyone who day after day is facing these challenges on the ground. We're here for you and we look forward to continuing to provide resources in the days and months to come. Thank you.